Computer's gonna be, oh, there we go. I think we're live.
All right. Thank you, thank you, thank you. Happy Sunday afternoon. It is yours truly, what I call Dr. G. I am so happy to be here this afternoon. And more than that, I am super excited because we are able to have a wonderful topic that I think a lot of folks are going to appreciate. Um, I have a, I will say this, I have a new friend. I get to get new friends every so often on this journey, called My Goal. So for the month of April, we decided that there's so many topics and issues out there that our families are dealing with that we wanted to really be able to provide more information and resources out to you. So I thought about some of the things that I have struggled with and areas that I've learned from. And one of the areas or topic that definitely, when I talk to even very close friends, are still very unsure about is the area of estate planning. What is that? What estate are you planning, right? And so I reached out to one of my colleagues, Hillary Freeman, from Freeman Law and Offices, and she collaborated with the concept or the topic we're going to talk about today. And so the topic today is take the fear out of estate planning. And I have a wonderful person who's joined me today, Brian Mondadori from Hill Freeman Law and Offices. And he's super excited. We were just chit-chatting right before we got into this topic today. And I asked him the question of what are some of the challenges of doing special needs law, and what are some of the joys that he does. And I'm going to let him share that part of the story. And it validated why we need to do this particular topic that we're doing today. So if you're joining us, this is my goal, where this to support families facing autism and other intellectual disabilities throughout their lifespan. And the vision has always been, how do we really make topics, how do we make issues that are difficult at least as simple as we can, knowing that it's still going to require some action. So, Brian, I want to say thank you so much for a Sunday afternoon. You were asked on a very short notice, and yet you agreed to do this. And so I want you to be able to tell our audience a little bit about your journey into this work that you do. I think you do a better job than I would, but definitely thankful that individuals and families will walk away empowered, educated, and perhaps the fear will be gone and really be able to make decisions that are sound to ensure that they can get their loved ones the things that they need. So, on that hand, I want to welcome you to As the Expert with My Goal, and we'll just take it from there. So, yes, welcome and share a little bit about your background and how we can take a fear out of estate planning. All right, so Brian, I don't know if you can hear me. Okay, awesome. I don't know if you're muted. I know I'm not hearing you, Brian. So now you're able to hear him?
Oh, come on.
Oh, there you are.
Oh, can you hear us, Brian? Like maybe, do you want to send a message in the chat, maybe?
Okay, let's see. So some slight technical difficulties, folks, so just bear with us for a minute. Uh, Okay, so while we're connecting, I'll read out a little bit of what Brian has on the slide regarding him. Okay, so he's not able to hear us. That's odd. So perhaps maybe we'll have you log off and log back in. So he's a special needs attorney who focuses on estate planning and guardianship matters, including planning for families, caring for loved ones,
I
and
can
special.
try.
Ah, there we are.
I can't. I can talk, but I can't hear anybody. Is that okay?
Okay, we'll work with that.
All right. So this is very interesting for me. I cannot hear anything on my end, but I see smiles. So that is great. So we can work. I do see that. Some of the slides that I prepared together are there, but before I jump into them, I just wanted to obviously thank everyone for inviting me. Thank you, Michael, for having me. It's nice to be able to be on a little feature that's called Ask the Expert of all things. That feels quite nice to be on a panel for that. And really, what I hope to do today is talk, obviously, about the big topic, which is estate planning, and talking about it, right? And talking, starting, right? Taking first steps is really, as far as I'm concerned, that is how we do take the fear out of it, right? It's an overwhelming thing that a lot of times, what happens? It's put off, right? It gets put off. We'll get to it later. Or sometimes we think, we don't need to do that yet, right? Things are good. I'm healthy, right? I don't need to worry about that yet. Well, that's not the case, right? Especially when we have, a loved one or someone in our family that's an individual with special needs, right? Planning needs to happen now when when that's our, the makeup of our family, or if we have a loved one that has special needs, we need to do it now, right? Because otherwise we'll run into some issues. But we'll talk about how we do it. How do we make it a little more bearable, and how do we, break things down so it's not too much. You could switch to another slide that I have, and let's talk about the putting it off part, right? Like I said, it feels overwhelming, which is very understandable. Sometimes when it comes to special needs planning in particular, like what should we have as part of our plan, sometimes we're not always sure, right? Because we don't know exactly what might be needed for our loved one down the road, right? Sometimes we don't know what levels of support. Sometimes we don't know whether there will be, right, support that involves planning that will be necessary. But the good thing is that we can be flexible with what we do, right? We keep that in mind and we plan accordingly. There's also terminology and concepts that you see up there that gets really, really overwhelming and complicated, confusing, different kinds of trusts and things of that nature. And another thing that pops up a lot of times, we're afraid to jump in the water and do this because we don't want to make the wrong choice. Right? We don't want to make the wrong decision. That comes up a lot. And more importantly, I think what I see is that this is an emotional thing to do, right? In more ways than one, right? So we're talking about, the grim stuff a lot, right? We're planning for when we're not going to be here anymore. But to add a whole other layer to that, right, for families that have an individual with special needs, well, we're planning for another life now as well, right? So let's talk about an estate plan generally and see if we can make everybody have a little bit more knowledge and feel a little bit more comfortable as we move forward. So if you could jump to the next slide for me, please. It's just a very basic one, right? What's an estate plan? It's the first question that comes up. I put a simple answer here, right? Everybody's gonna go, yeah, duh, Brian, we know that, right? It's a plan, right? It says what's gonna happen to my stuff. Where's it going to go? Okay. But if we hop to the next slide, what it really means is it's more, right? There's more to it than that, right? For this audience, I suspect, right? It's about not just deciding what happens to assets after we pass, right? There's a bigger plan, right? We're talking about care moving forward, right? We're talking about decision making, management of finances, preservation of options, right? When we talk about that, are we going to have a need? Is someone in the family going to have a need for means tested benefits in the future, right? That is the biggest piece, right, for many families. It's not just about transferring those assets. Like I said before, we're talking about planning for, another life as well. Now, I've done a lot of engagements where I've spoken about estate planning, and what I've found is that one definition, or that I'll steal from someone else who stole it from someone else who stole it from someone else, by the way, is that you see that on this slide, I have the word control big and it's underlined. And that is really the way that I'd like everyone to think about estate planning, right? It's all right. So what do I want to have happen, right, with my property? How do I take grab of this and hold this while I'm alive and while I'm able to do it? Right. This way I could say, well, what do I want to do with what I have? Right. To whom do I want it to go? And I think in our situation here, how do I want it to go there? Right. That's one of the biggest and most important parts, because if we have things go to our loved ones the wrong ways, then that's when we start having an issue. And this is why we need to start planning for that in advance, for that other life. You could go to the next slide, please. This is a big question that comes up a lot. Well, what if I don't have one? Well, just very simply, if you don't have a plan in place, and this is why I say some plan is better than no plan, well, then guess what? The state gets to pick what happens to everything, right? And I think everybody knows that we wouldn't want that to happen. Then we have no control, right? We have no control at all. We don't get to say who it goes to and how it goes to that individual, which is problematic. So here's what we want to do. I have another slide, and this, okay, this is maybe some place that we could start thinking about this if we're afraid of planning or we don't want to get to it. Answer these 3 questions, okay? The top one you see, right? Who will help care for me or my loved ones, right? Who are we going to possibly be leaning upon? Who would be the right people or persons for that, okay? Second, who's going to make decisions if, right, that support's needed? Now, we're not just talking about for yourself as an individual now. Maybe we're talking about a child, okay? Maybe we're talking about a family member with special needs, okay? And when that is the case, we also want to know, right, who's going to manage and money the resources as well. That's also another massive consideration. So when you hear me talking about in terms of that, one of the things that you'll hear about is a trustee, right? That about who's going to be handling funds, managing assets. One of the things here, though, is that sometimes people get overwhelmed in trying to figure out who's going to do certain things for them when it comes to their estate. I'm going to throw some terms out there that you may have heard before. And if you haven't, you're going to hear them now, right? Your executor, right? Who's going to be the one that administers your will, right? We talk about agents. You have your agents for whether it's healthcare decisions, financial decisions, who's going to be making those. In many situations when we have minor children or children with special needs, it could be guardian is a term that comes up. Who would take that role over if I couldn't handle it? And another thing you'll hear would be trustee. That ties into managing money and resources. Where people get overwhelmed sometimes is themselves. They think about who they're going to rely upon down the road. And they start thinking sometimes, well, now I'm getting overwhelmed thinking about how overwhelmed this one person's going to be that I might name to do these things. Well, good thing is this, is not every role has to be filled by the same person, okay? The reality is that sometimes there's someone that, whether it's a family member, a friend, whoever it may be, that we might be able to rely upon and name when we do our planning. One person might be really good at the financial stuff, right? One person might be really better suited to handle medical issues, right, or concerns. I see that a lot of times in families, right? So you can break up these roles, split them up. And, when you consult with, maybe you'll decide to consult with an attorney on these types of things or other, professionals, you can kind of have, right? You can go through who might make sense for different kinds of roles. But the point is that, when families start to understand that the roles can be separated, right, and that there's other ways to support these roles, okay, like for example, if we're doing a trust and we might want someone to serve as a trustee for us down the road, well, we want to be flexible, right, we can, if we do a trust the right way, we can put provisions in there that allow the trustee to be supported. Okay? A trustee doesn't necessarily have to be a CPA, right, and know all the accounting rules. They don't have to be an attorney and know all legal rules. They don't have to be someone that knows all the special needs rules. But if we plan accordingly and we put our trusts together in a manner that makes sense, well, we can enable a trustee, right, maybe to engage other professionals or individuals who could assist them, right? So when we start to break down these things and talk about ways that we're not piling on everybody, again, it sort of adds some relief. It starts to make the process feel more manageable and a little less burdensome overall. So if we hop to the next slide, I'm going to point some things out that may be obvious to some folks, things that you've heard, but these are the core pieces of your plan, right? When we're doing your estate planning, you don't want to think of it just as a piece of paper, right? It's not just your will. It's not just one document. It's a comprehensive plan, right? That's going to have to work in unison. Okay. Obviously, we have, at the top, you see that I put last will and testament. That always remains important, right? Yeah, for parents of minor children or children with special needs, that piece of your plan is more than about just saying what goes where, to whom does this go. There's other components to that, right? This could be where we are indicating, well, I might want to make a guardian nomination here, okay? I may also want to, say what happens in terms of how things are distributed to my beneficiaries. Again, in this case, to whom, may something need to go, but may need to be held in trust, right? As opposed to going out. There's some topics that we'll talk about as I get through this. Revocable living trust, you'll see that there. I don't want to go too deep into that right now and overwhelm folks, but one of the questions that I get a lot of times is, what's better, right? Is a last will and testament better, or is a revocable living trust better? Well, I think it depends who you ask. It also depends on what individuals' needs are. But the reality is last will and testament, that is going to dictate how your assets are distributed, right? Who do they go to? We said this before. One thing I'll mention is when folks say that a revocable living trust is better, when they use that term better, and I'm doing some air quotes that you may or may not be able to see, they say that because the last will and testament, it's only effective when you pass away. Okay? It's not in effect during your lifetime. As a matter of fact, during your lifetime, while it is still a very important and major piece of many people's plans, it doesn't have any effect. Okay? What happens is if you write one and you have it, if and when you eventually pass away, right, whoever is in control of administering your estate, your executor, they'll be the ones that would now have to take that will to probate, get authority to distribute your estate as you've set forth there. The revocable living trust, the whole better part, why some people might think it's better, in their opinion, is because it is in effect during your lifetime. Okay, so what that means is if you have property and you decide to put it into your revocable living trust, let's just say a bank account or a brokerage account, for example, that trust says, right, how that property is controlled. And any property that you put in it, right, if you become hypothetically incapacitated, right, during your lifetime, well, guess what? That trust controls, right? Your trustee's already in control of that property. They don't need permission, right? So it's in effect during your lifetime. So if anybody ever wants to talk about that, right, that's something you can call me about, but I don't want to go too deep in the woods to that. But I will say this, that in New Jersey, the probate process, which is something a lot of people are fearful of, it's not necessarily the most tedious state, for it. It's not as expensive as other states. But whether one will be better for you or the other is really going to be very fact specific and, relying upon sitting down with someone and seeing what makes sense for you. General power of attorney, that's there, of course. I don't want to go too deep into that. I think that's a common piece of the plan that most folks know about, but it's critical, right? Who's going to handle financial decisions if something happens to you? At the same time, if you do become incapacitated, for what I like to do for folks is, if you have a minor child or if you have a child with special needs over whom you maybe already have guardianship, that happens sometimes. It's another place where we want to nominate. Well, if I'm incapacitated, well, here are the folks that I'd like to step in and take care and handle matters for that loved one that I have. I will mention this as a side note, even though it is a great idea to do that in your will and in a power of attorney, it's not dispositive, right? It doesn't mean that automatically happens when we have an individual over whom someone may have guardianship. You still have to go to court, okay, to get that actual authority. But nonetheless, if an existing or serving guardian has named that, it makes your position for going and becoming that guardian, whether it be temporarily in an incapacity situation or permanently after someone's passed, makes it a lot more helpful. Healthcare power of attorney, same thing. We need to make sure that you have that in place as well, because if someone's going to make decisions for you, you want to take control of that now, right? Who's it going to be? Pick somebody. For many folks that are married or have a partner, they'll say, well, it's my spouse or it's my partner. But then we need to think of another level, right? Whether that is a child, if you have one that is old enough and that is fit to do it. If not, we're thinking about family members sometimes. And if not, we're now thinking about siblings, right? Family member wise, but maybe to the next level. Sometimes nieces, nephews. These are all, again, things to discuss, right? When you're thinking about planning, you have that discussion with a professional and figure out what makes the most sense. Living will. I just want to be clear that a living will, it is not a DNR. Okay. Some people ask me that, but the living will is essentially something that you are putting in place for yourself, right? And basically saying, look, if I have no maybe brain capacity, brain function, something like that, what your wishes would be in that scenario, right? A lot of people have different opinions on that. But making that known, okay, is something that can take a heavy burden off of another family member, right? HIPAA authorizations, some folks and some attorneys will have that, but they'll have it within their healthcare power of attorney. Just practice point for me, I like to keep them separate. I do think it's something you should have. And the reason for that is when you have the HIPAA authorization, it obviously allows someone to have access to medical information, right? And you can limit the extent to which that is in the document itself. But in many situations, I come across this for families that sometimes they have a child that's an adult that they would like to be able to ask a question, to maybe talk to a medical provider if need be. But maybe the parent doesn't necessarily want that child to be a decision maker, right? So this is why I like to separate these pieces. So that's something you can consider yourself. Big thing, of course, I know, special needs trusts. You'll see supplemental, I have in parentheses there. The reason I do that is because there's a variety of different types of special needs trusts. We'll talk a little bit about that, first party, third party. Supplemental is one of the big pieces that we want to have when we're doing our estate planning, right? We are looking to supplement, right, any means tested benefits a loved one of ours may need now or in the future. And another thing that folks often never contemplate or maybe never heard of is a memo of intent, right? I like to have all of my clients create a memo of intent and leave that with a trust that they might create for a loved one, because I think it's valuable, right? It allows your trustee to know more about the beneficiary, right? It allows the trustee to know more about what your intents were, right? It explains the beneficiary's life. Who are trusted individuals for them? Who are they comfortable with? What are their preferences, right? What do we want to have? It's more the in detail stuff that we wouldn't necessarily put into a trust itself. It would be maybe too much and not appropriate for there. Now, what I like to do for clients is actually give them some guidance, at least written, to say, well, here are some, head points, right? Some headers to maybe put or think about when you're doing a memo of intent, right? So we're basically, again, what are the routines, maybe? For some people, it could be what's their communication style, right? It could be, well, what you absolutely shouldn't do with this person, right? Because that, would not work out well. You know, sometimes it could be hobbies, right? It could be things of that. These are some things that really make this individual happy. And part of my intent in creating a trust for them was to make sure that, well, this thing that they love to do, which is not going to be provided for through any government benefit, well, I want that to be done, right? So again, these are things to talk about if you haven't already with, anyone or any professionals that might assist you in putting your planning together. If we go to the next slide, we don't have to go through this in full. Again, it's just general power of attorney. That's what we have. That's a piece that we already spoke about. The reality is those could be broken down in a number of ways, right? But we want to think about who's going to be doing financial stuff for us, right? It's not even just the financials. I really call it handling your business, right? Because sometimes it's more than just money. It could be things that we don't think about. That, well, if something happened to me, I don't know. I have digital accounts. I have memberships, right? I have things that we don't ordinarily think of. It's not just somebody could write a check for me or get information from my bank. No, there's other things, right? We have people have insurance policies, right? People have real estate, right? So it's really handling your affairs, right? So we always have to sit down and think about, if I needed someone to do that, if I was incapacitated, who's going to be the person or persons to do that? The other piece, again, healthcare power of attorney, you could go to that next slide for that. Same thing we just spoke about a moment. Choosing that person wisely, right? Can they handle the responsibility? Would they be able to make a decision, right? Some people might not be fit for that. And I don't mean fit that they don't have the capacity to do it, but I mean sometimes it's the stomach to do it. Might not be able to make a decision or wouldn't know, how to do it. There's a variety of things that can happen. People could freeze up. People could just be uncomfortable. But these are a lot of the things that come up that make people afraid of the planning, right? We're talking about roles, who's going to handle it. Is this the right person? Is it the wrong person? You don't always know. But one thing that I like to tell people is, we can select, we do our best, right? We do our best to put people in place to line us up with successors to take care of these issues for us if needed. And the other piece that comes up a lot for folks is, well, I don't think that person's going to want to do that. Well, here's the thing is they don't necessarily have to accept the role. Okay. So I think it's good especially when we're thinking a little bit further ahead, when we're thinking down the road and planning, and we start getting to that later part. This comes up a lot. I know this slide says healthcare power of attorney, but I'm going to switch gears though and talk about the trustee component a lot, because that a lot of times is where we get I don't know if somebody would want to do that, right? This is where we get to well, now I'm not thinking about just during my lifetime. I'm thinking about after my lifetime. And some cases, parents will say, well, look, the person that I want to serve as a trustee after me, for example, that maybe it's a sibling of another child that I have who has special needs and who's going to be the beneficiary of the trust. But then we start thinking about the next line and we start, now what if my child that is the beneficiary of the trust, maybe they survive the trustee, their sibling? Right? This is where we start scrambling a little bit. Are we now considering maybe nieces, nephews, younger generation? Okay, so that is something that, right, we have to kind of line up and come up with an idea for. And a lot of people will say, I don't know if they would want to do that. I don't know if they could handle that. Well, you know what? It doesn't hurt to name someone who you think might be able to do it and handle it. And if they don't want to, they don't have to, right? They don't have to accept the role. Even if they do accept the role, we do things with flexibility, right? We design the trust so they could, step down if they wanted to, put provisions in for naming a successor later if it's necessary, right? And other things too. We might discuss the possibility of seeking, a private trustee, a professional, corporate. But for many other families, the idea would be if they did not have a family member that would be able to do it, then we might be thinking about a nonprofit organization, right? So there are nonprofit organizations out there that do offer guardianship services and trustee services. So that's a good alternative to look into and become familiar with some agencies that do that to see if there's one that you might have comfort with, right? So many of my clients, that's what we do. We might go through the list of possibilities of who in the family could serve, because that's what most folks that I come across want anyway. I do have some folks that want professional trustees. I think that's less common, at least in my experiences, because of fees and things of that nature. And of course, wanting someone that maybe understands their beneficiary a little bit better, right? Not such the professional, while there maybe is more of an interest in money than really in the individual themselves and what their actual needs are and really knowing them. But some of the nonprofit organizations might give you that better feeling, right, as an alternative. And so what we'll do is, maybe leave that as a last, I hate to say the word last resort, but as a final backup and, put some other provisions in. So look into that, find out what type of organizations in your area might provide those services if you think that could be a need for you, and get familiar with them. That way you would know, hey, I would feel not too bad if that was necessary by appointing someone there. Let's see. I'm going to skip ahead a little bit and get really to some of the nitty gritty. We can go past the living will slide. We already spoke about that. But this is what things are all about, right? This is really the meat and potatoes on a day like today, right? Why special needs planning is so, well, right there, right? The big key is right there, that you could go ahead and have a big, oops moment, right? That we don't want to have, right? It's different than traditional estate planning, right? Direct gifts, direct inheritance, if we have a loved one with special needs, can create unintended consequences, okay? Where, right, whether it's now or in the future, where we have a child that might need means tested benefits, SSI, Medicaid, other ones, we don't want to create a problem. We don't want to now create an issue where they receive a direct inheritance and now they're ineligible for the supports that they need, or maybe that they could need in the future. Now, I see some folks handle this, or they have handled it. Not through me, they don't, I can assure you. But some folks have come to me with maybe some out-of-the-box approaches, I guess I could call it that, where they've said, well, all right, if that's the case, I know I have this understanding that, whether it's my child or another beneficiary of mine who has special needs, well, we just won't leave anything, right? No. That's not the issue, right? The issue is not whether we should just not leave anything, or no, absolutely, right? You should absolutely leave something. So you see there, I have in parentheses no disinheritance. I've seen that. That I don't want folks to do, right? So the real issue and the real way to approach this is not about, whether it's a give or not give. The answer is going to be yes there, but it's a how to give, right? How inheritance and support should be structured, okay? And some of the common problems that we have, again, and you're going to hear me hammer this point over and over again, outright gifts. Sometimes it could be even having a trust together and directing something to a trust, but the trust could have improper standards, what we call, right? It could require distributions for certain things, which is sort of the antithesis of a special or a supplemental needs trust, right? So improperly drafted trusts or the wrong type of trust. You heard me mention before a few different trusts, right? And I think the big distinction is that first-party trust versus that third-party trust, okay? So what I've seen some folks do, a problem that I've come across, is someone has gone ahead and they thought they did everything the right way. Maybe they even ventured out to try to do it on their own. And hey, nope, I did an estate plan. I went online. I found a few pieces. I drafted it up. I clicked a few buttons. This place, created the documents for me. And then we find out that there are provisions in their supplemental needs trust. So they thought for their, let's say their child, that have provisions that only belong in a first party trust, right? And provisions, what I mean by those provisions are payback provisions, right? So first party trusts, they have payback provisions in them, right? That's a big difference. So if we go to the next slide, I'll start talking a little bit about the different types of trusts and see if we can make a little bit more sense of them, right? So the trusts, first and foremost, they could do these things that are here, right? So when we think about trusts, I want people to think about that. This is not even something that has to be funded during your lifetime, okay? I want to be clear about that. Some people think, well, I don't have anything right now to put. That's okay. That's okay, right? Trust planning is not, some people have this misconception that trust planning is for super affluent or super wealthy people. No, trust planning can be for everyone. Trust planning is absolutely for us, right, in this context, right? In this arena, special needs family members is 100% within what we need to be doing. Because, right, it could hold inherited funds, right? You could think of it as a bucket, right? It's this safe place for an inheritance to go. Okay, you could receive life insurance proceeds, right? You may not have that something now, but maybe to cover yourself, your family, in the event something happened to you, maybe you have a policy. Okay, well, the supplemental needs trust can be a place where that could go. And the whole main point there is, right, it's protecting eligibility for certain benefits, right? As your SSIs, your Medicaid, or any other kind of means-tested benefit. That's what this is all about. And that is to provide, again, you see I have the word underlined there, supplemental support. Okay. The common types you see here, again, keep saying it, your third party, your first party, and your pooled trust. The pooled trust can be either first party or third party. Okay. The third party trust, one of the best ways to really understand that is it's going to be a trust for your beneficiary, for your loved one who has special needs. Okay. The property that will eventually go into that trust is property that never belonged to the beneficiary. It never will belong to the beneficiary. It will only belong to the trust for the beneficiary's needs. Okay. This is a big difference. Okay. What we have to do when we put those trusts together is they have some magic words in there. There's some magic language, right? One of those phrases or lines is that the trust is intended, again, to supplement but not supplant any means-tested benefits, right, for which your beneficiary may be entitled now or in the future. Okay, that's really the point. These types of trusts, they're fully discretionary. Okay, it means that the trustee, the person who's managing the funds, is not required, okay, to make distributions, right? There are some trusts that have distribution standards, okay? That's that word that I said before. This is very common in just in regular old trusts, I'll call them for lack of a better phrase, where there might be funds in a trust for a person, and the standard that is set, it says, well, the trustee must distribute, right, X percentage of the income that this trust earns quarterly, annually, whatever it may be. And a lot of times you'll see, well, it's got to be for health, education, maintenance, and support, right? That HEM standard, which is some language that comes out often. Well, again, you heard me say the antithesis of a special needs trust earlier, and that's what I'm talking about. If there's a trustee is required to make a distribution, that would be a problem, right? That would be a drafting problem for a third-party supplemental needs trust because it means that, well, that's an available resource for the beneficiary, which is not what we want, okay? The third-party trust, though, going back to what I said, how it is money that does not belong to the beneficiary, never belongs to the beneficiary, and it never will. That is key also because this relates to the fact that these types of trusts are the ones that don't have a payback provision. All right. So this is something that there can be, okay, I'll say a residuary beneficiary, right? So this is something that if we do the right way, you can leave funds to a loved one with special needs, have it managed in a manner that's not going to disqualify them for means tested benefits. And then when that individual eventually passes, we can say, well, I now want these funds to go here. Sometimes it's a, well, if my beneficiary has children, right? I would want it to go to their descendants if that's the case. Well, if they don't have any descendants, maybe it's a, well, now I want whatever's left to go to my descendants, right? Maybe we even take it a step further. We say, well, if it's not my descendants and I don't have any, well, then these are the individuals I might want it to go to. Okay. Without getting too deep in the water on another overwhelming topic, because I don't want to go there for today, some people will think, oh, maybe a charity or something along those lines. Well, maybe, but it's something that we have to be careful with when we're dealing with special needs trusts. Okay. Sometimes people might have a retirement account, right, that pays out into a special needs trust. And if we don't have it set up the right way, let's put it that way, and we have some beneficiary designations in the trust that could be a charity, we could create problems related to retirement accounts. It's another full topic, okay, but I'm just touching upon that lightly. But these are things to think about too. Right, I said before, who do we want to make decisions? Who do we want to control things? Well, who do we want our things to go to as well? Right, that's a piece to consider and think about. And how do we need it to go to them? Pooled trusts, okay, real quick, those are available first or third party. This is usually in the arena of a nonprofit organization, is where you might, go ahead and entertain a pooled trust. I think really that in and of itself is a separate topic, because most people in their planning are usually not initially planning to have a pooled trust, right? Maybe if someone has special needs and they maybe become the recipient of settlement funds, they might decide to do a first party trust. A pooled trust was a D4C trust, right? That might make sense depending on the amount of the settlement. But even in that regard, if it's enough, a lot of people are usually looking to a first party special needs trust. So this is where the major differences are, right? With the first party special needs trust, the money that goes into it belonged to the beneficiary. Okay, so I just want to make that clear. With the first party special needs trust, it's funded with money that belonged to the beneficiary. How does that happen? Well, some of the ways that could happen, one of the very common ways is what I just mentioned a moment ago, settlement funds, right? Maybe they become entitled to settlement funds. There was an injury case or something along those lines. And now this individual becomes entitled to the settlement funds. And then, of course, the is, well, we can't do that. We can't have that. Because if I'm going to be over, if I get the settlement and it puts me over the $2,000 resource limit that exists for an SSI or for a Medicaid, I don't want it. I'm going to have a problem. Well, this is why the government allows for the first party special needs trust. Okay, we're allowed to take funds that belong to the individual with special needs and place them into this. Now, these types of trusts can actually be created by the individual themselves, right? If it's appropriate and they are able to do so. It could be created by a parent, grandparent, legal guardian. Okay, so they can be created by a number of people. And if there is a situation where the beneficiary is someone over whom, like the trustees have a guardianship, it does require a court approval, right? Anytime you can't just, even as a guardian, you can't just take someone's funds and go, I'm going to put them in that trust because it makes sense. You still got to get court approval for that. But here's some of the bigger ticket and bigger key items with this. The reason the government says, yeah, okay, we could do that. We'll allow you to put those funds in there to preserve your, eligibility for benefits, is because there's some strict rules. Okay, The biggest one is the payback provision, right? If funds are in this type of trust, when the beneficiary eventually passes away, the first person to stand in line to collect is the state. Okay, so essentially, dollar for dollar, what the state may have put out for Medicaid recipients' care over their lifetime, the state is there with their hand first. They're allowed to recover from that. So ultimately, what could happen is if there were a large settlement hypothetically, right? Oh, well, if there's remaining funds and you're thinking that maybe it's going to make its way to someone in the beneficiary's family, not necessarily, and maybe not at all. But why this is more important for folks that might be listening today and thinking about planning in advance is because we want to avoid this. All right, because this one of the other ways that we could find ourselves in a situation where we would have to create a first party trust would be is if our beneficiary inherited from us outright. Right? When a beneficiary receives an outright inheritance, that could be either through a will. All right, so let's think about this. Through a will, if we allowed the beneficiary to inherit outright, that could be trouble. It could be because we didn't do a will at all. And the state said where our stuff has to go. And one of the things that has to happen is, well, some of my property has to go to my child, right? Or whoever the other beneficiary is that might have special needs, right? That becomes their property when that happens. So therefore, we need a first party trust. The other way I've seen this happen many times, and it's usually not the parents. Sometimes it's another family member. And whether it's another family member or not is not the point, but it's through beneficiary designations, right? Sometimes people will even have a plan in place. They'll go through all this trouble, but it's not properly coordinated with beneficiary designations. Oh, I did a will, I did a trust, and oh, that insurance policy, I forgot. It has my child's name on it, my child with special needs, who needs means-tested benefits. I forgot to put the trust on there. I left it in their name. Well, guess what? Now it becomes their funds. Okay, so that policy now can't go into the trust maybe that you took the time to create because it now belongs to the child and it has to go into a different type of trust. Okay, so that's something to know and understand, that when we're planning in advance, third-party supplemental needs trust, no question, no question. Okay. Let's see slide-wise here. Yeah, ABLE account. We should talk about that a bit because I get questions about ABLE accounts all the time. One thing I want to say to be fair is you don't have to call an attorney and pay an attorney to get an ABLE account. All right, so that's really important. People call and they think, no, that's not what it is, right? You do have to find. You can't just go to a regular bank, all right, and open up an ABLE account. I want you to know that as well. You would have to look for, like, there's the National ABLE Account Resource Center is an excellent place to look. But you can go local, right? You could look NJ ABLE, right? You can get an ABLE account through there. There's also other states that have ABLE accounts too. So you could look into that. Each state has their own and see whether you might be able to utilize one or if you think maybe it's more favorable or beneficial to use another state. But here's the whole point here. ABLE account, it's another tool, okay? Let's talk a little bit about what it can do. All right, you see here that I have the tax favored savings there, right? So in the ABLE account, whatever is in there, it grows. It's not taxed, but the caveat is that the funds have to be used for qualified disability expenses. Want to circle back for a moment too on the same topic. That applies to a first party special needs trust as well, okay? Any distributions from that trust, similar to an ABLE account, would have to be for qualified disability expenses. That is a rough question for me as an attorney, I assure you. And I have to laugh to myself a little bit because it's always, what is it qualified? Well, it could really be a lot of things, okay? And it's one of those it's a little bit of a gray area. Let's put it that way. One of the ways I like to look at it, though, is, well, it's basically something that is something that means-tested benefits are not providing. Okay, like, right, it's something that they're not providing for you, and that might be a way to look at it in a very simple spot, right? There's probably a variety of ways that any given expense you can argue cuts one way or the other. Okay, so I don't want to give like specific examples on that, but they often fall into the territory of what you see on the screen there, and that's why I kind of kept it broad. Okay. Now, the other thing too, before I get back to the able account, is with that first party special needs trust, if you have a larger expenditure, I did not mention this before, and I want to make sure I do. If you have a larger expenditure, specifically in excess of $5,000, with those types of trusts, you have to go ahead and get permission 45 days in advance from the state, and I'm talking New Jersey here, to make an expenditure in excess of $45,000. So that's another piece. There's a lot of restrictions associated with those. Now, going back to this, having the able count, it can really be a useful tool that provides you with flexibility. Okay, and again, it's not going to be something that's going to be for massive amounts of assets. Okay, there's issues we can run into there, and we'll talk about that in a minute. But it could just help a beneficiary manage day-to-day expenses, right? There could even be a debit card that can be used for it, right? You could save, and it could be used for paying for a variety of things. I don't want to get into tricks of the trade right now, for like, there's maybe one way I could put it. But if you ever do work with a professional, an attorney or anything, you could find out, as it applies to your personal situations, some things that may be enticing in terms of, well, this is how we might be able to utilize the third-party trust in conjunction with an able account, possibly to pay for some things that a third-party trust might not otherwise be able to pay for. Some of those things that I'm talking about right now, it's really, when we are talking about, you'll see where it says like housing and things like that. It's a tricky topic, but one that's worth talking about in depth later. I think right now the point is to know that it would be good to utilize the able account in conjunction with the SNT. So I want to talk about it in the sense it's another thing that, because of those payback provisions, right, the government allows that, right? This can be funded with the individual. Well, it is funded typically with the individual's assets, but other folks can make gifts to it as well. Okay. I put on here for everyone to see. I'm going to hop around a little bit, so I hope it doesn't get too difficult to follow. It's on the same slide, but I wanted to mention here that there's a contribution limit annually. Okay. So you can only, for 2026, it's 20,000. That's the standard amount. This can get a little more complicated in terms of sometimes an individual has an able account and they're working as well. So one of the questions that often comes up is, well, is it just the 20,000, or is it, what if they're working? It could actually be a little bit more. Okay, so if someone's working, there could be an amount that they're allowed to put in on their own, right, through working, in addition to the amounts that might be able to be saved up in there that could come from a family member as well. But I think for today's purposes, let's stick to thinking of it in terms of $20,000 of a maximum contribution annually. And just so everybody knows, it's usually the same number as whatever the annual gift tax exemption is. That's how it usually works. They mirror each other. Now, going back, I want to talk a little bit about the eligibility aspect, right? So you see there I have receiving SSI or SSDI. That pretty much would be like, automatic eligibility. Not everybody is always on one or the other, but we have here that the disability that is at issue, right? It has to, those are the terms that are in quotes there, marked in severe functional limitations. Okay. That's the standard in the statute. And it used to be that it had to be the case before age 26, but luckily it just changed very recently. So for this year, it's before age 46. Okay. And that limitation, right, that marked in severe limitation has to be expected to last for more than 12 months. And there's another component to it that I put here, but it could also be if someone is in a situation where they're terminally ill. Okay. That's as well. Doesn't matter if a person's working, as I said before, right? You can be working. But here's the other key piece to remember. And this is why I said before that the ABLE account's not really a place for a large amount of assets. First $100,000 that would go into an ABLE account, if someone was fortunate enough to have that much in there, it's disregarded for SSI eligibility. Okay. However, after that, it's counted. All right. So what could happen is there could be a pause, right? Another question that comes up a lot with this is, what about the Medicaid piece? You're good on Medicaid, right? So it's not as though if you were to exceed that amount that there'd be a pause for Medicaid, but there would be the pause for the SSI eligibility, okay? Where you see the other piece that would come in is right there, that for this number, 305,000, that's for New Jersey. Okay, that's specifically for New Jersey. That's the maximum contribution amount. And in reality, I don't think I would ever have clients that I would want putting that substantial amount of money here. We would talk about other planning pieces. But again, it's another tool to use. And as you see here, some of the drawbacks, the state can claim to reimburse, so that's the biggest drawback, just like the first party trust. And the other piece that I want to mention, because this comes up many times, that some people will think that if you direct an income stream to an ABLE account, that the income doesn't count in the analysis for means tested government benefits. One of the things that I see this come up with most, I think, is sometimes child support. Okay, some folks will think that, the child support is going into an ABLE account. The ABLE account is there to help with the resource limit. Okay, I just want to make sure that everyone understands that's a big distinction. It's a resource limit that it helps with, right? Anything that is in an ABLE account, it's not going to count towards that $2,000 resource limit for an SSI or for a Medicaid. But if there's an income stream flowing to it, we still have to worry about that other part of the analysis, right? Because if we're over a certain amount of income, then that could make us ineligible for a particular means tested, right, government benefit. Now that could be for SSI itself, if that's what it is, or it could be for a particular Medicaid program, depending on which Medicaid program it is. Okay, so there's several different Medicaid programs. All right. Now, we can hop to the next slide, and I'm going to grab a little sip of water while we do that. Age 18. Right, we're not just planning for age 18, of course, but this is a big, big change, right? It's a big time period for us, right? Child's becoming a legal adult. Guess what, parents? we don't have full legal authority anymore, okay? We don't have the ability to just show up and ask the questions and say, this is what's happening, this is what we're doing. It comes as a surprise to a lot of parents, right? So maybe it was doing the things that we expect to keep doing all the time, making the appointments, having access to the statement or something, access to an account, talking to the school, right? Now, granted, there's some easier ways, right? When it comes to just like the public schools or something, you can sign, it could be signed and it's easier there. But what happens now if we're not just talking about public school anymore? We're talking about maybe a transition program, or we're talking about a day program. We're talking about work, right? We're talking about anything that our adult child, right, is doing, that we can't really meddle in that business anymore unless we have the authority to do so. Okay. So this is something that we need to start talking about. We need to start planning before age 18. Okay, we need to start having an analysis of what might make the most sense here and when can we get that process going. Okay, we could jump to the next slide. That would make sense here. Here we go, decision making, right? This is what it's all about. Possibly guardianship, I don't know. That's the whole point, right? Possible approaches. These are options, right? Sometimes it's just informal support, but what could happen again is maybe we're just trying to do what we always did, and now someone's shutting the door on us, right? Whether it's a doctor, it's a facility, it's a financial institution, whatever agency you can imagine, okay? So this is where we circle back to some of those pieces that we said before. HIPAA releases, powers of attorney, they're not just for you, they could also be for your child, okay? We have to figure out what makes the most sense, okay? Representative pay arrangements too, I don't want to forget about that. I almost skipped right over it. That is another thing that will be for like your SSIs, okay? Get that set up so somebody is able to accept those payments, manage them, and get notices about them. But the big question always comes up for many folks and families is the guardianship question, right? We're planning for 18. Maybe we don't know. Maybe early on we don't know, and obviously we can't do any planning when we have a child that's not even nearing age 18. We can't start. We're still in control, right? You're still parents, but when we get to the point to now we're reaching 18, what are we going to do? How are we going to handle it? One of the good things is that guardianship is available if and where appropriate, right? If it's necessary. But which one of these things makes sense for the individual, it varies, right? This is highly fact sensitive. I don't want to talk about this here, and maybe talking about guardianship more in detail would be more appropriate to do it. Sometimes there's a lot of cases where guardianship is questionable, right? Let's put it that way, where it could cut one way or the other. Maybe it would be appropriate, maybe not, maybe it's too restrictive. And then sometimes the family themselves have, and when I say the family themselves, that obviously includes the individual, right? Who's at the center of all this. Sometimes it's something that they may feel that that's even a better arrangement, right? In some cases, but it's not always. And again, it's highly fact sensitive and highly individualistic, right? Really, what is in that person's, not just in their best interest, but what do they want, right? What do they feel will work best for them? That always has to be part of the conversation. I think sometimes that's forgotten. But nonetheless, where guardianship may be appropriate, I want to talk about this, that this is brand new this month, okay? I believe it was December, New Jersey signed into new law that for an individual with developmental disabilities, it allows parents to file for guardianship up to 180 days before the minor's 18th birthday, okay? Now, even though that was signed back in December, it just went into effect April. So some of the guardianship work that we're doing at families, for those it makes sense for and who it's appropriate, we've just started dipping our toes in the water on doing this. I don't know. There'll probably be a lot of changes in terms of how it's handled in each various county. Nonetheless, that's why, when you're working with us, we'll figure out what's right, what makes sense, what needs to be submitted to get you through. But the important part to know is that now, because of this, especially when we're dealing with developmental disabilities, planning for this in advance, right, even more than we had before, makes a lot more sense now, right? It's almost even necessary, right? We want to close that gap, right? If we have a scenario, if our loved one might actually require guardianship, that might be appropriate. We don't want there to be well, great, we turned 18, and now we're 18 and a half, and we still don't have an order, right? We still don't have a guard. I still can't do what we need to do, right, in this situation. So that's why we're going to jump on that early and even earlier now. Okay, so keep that in mind. I want to talk a little bit about, if we jump ahead, about mistakes, right? Because this, I think, when I talk about mistakes, when we talk more about what not to do, maybe, I think really that's how we start to take the fear out, right? Like just knowing what not to do. And I don't want to say suck it up, right? Because I don't mean it like that. But realizing that there's some things that we need to do, and if we just start taking some of the steps in the right direction, we can feel much better, right? We can feel much better. We don't have to be afraid of this process, right? So no plan at all, one of the big ones, okay? I mentioned that the reason we can't have that, right? There's resource limits, and we can't go above those and create an unintended problem. Same thing, same way we do that. I mentioned this before. Also, is outright gifts to the beneficiary, right? No good. The wrong beneficiary designations. What I mentioned before, right? We have our retirement account, maybe we have a bank account, we have anything for that matter, and we accidentally put right a beneficiary's name on there who's someone that needs means tested benefits. Well, we're going to have a problem, right? We don't want that. Sometimes I see this too. I'll mention something specific. Is I will have clients that, for whatever, it may have made some other type of logical sense. There was another intention there where they put their child's name on the account with them, right? The money's not the child's money, right? Everybody in the family knows that it's the parent's money. Well, the problem with that is SSI and Medicaid, they don't care, right? So if there's this account that it's all my money, but I put my kid's name on it for it to make sense, and it turns out that that child of yours needs means tested benefits. Well, when we go ahead and we are looking to see if you're eligible, if your name comes up on that account, as far as they're concerned, that's an asset. It's accessible to you because your name is on it, so it counts as a resource. The other thing too is we need to look at this stuff now, even if we are not at the point where SSI, Medicaid starts to become a consideration, because there are look back periods for eligibility, right? So if we think we may need eligibility for SSI in the future, there's a 3-year, right, look back for that. And if we're talking about Medicaid here in New Jersey, there's a 5-year look back, okay? So what happens is, right, I have a lot of clients that they might require supports and services through DDD. Well, that's funded by Medicaid, okay? And if we're thinking that we're planning, right, again, planning is not just where's my stuff going to go. It's how are we going to have care lined up, right, for our loved ones. And part of that planning and planning for those other lives is this exactly. So if we think we're going to require that eligibility, well, if I have my child who's going to need those supports and services, if I have their name on an account, I better take care of it now, right? And try to make sure we're doing that well in advance of needing eligibility, right? 5 years, okay? Because what'll happen is what happens when anybody needs Medicaid eligibility is if they had access to an asset, and let's say I'll stick with the same example. Parent has, let's make it a simple, $20,000 in this account, okay? And they put the child's name on it. And now within 5 years of applying for Medicaid, that comes up, okay? Medicaid is likely to treat half of that, okay, at least half of that, as the child's funds. So what has to happen then is, well, what happened to it? Well, I took my adult child or the child's name off the account. So technically what that means to them is that the child, the person who's applying to be eligible for benefits, technically they gave away that asset without getting fair market value in return. So what happens then is, because of that, there now has to be a period of ineligibility for that Medicaid, right? What they'll do, the state, is they take a divisor. They have a number, and they'll divide it into the amount of funds or assets that were given away for less than fair market value, and they'll get a time period. So now you'll be ineligible, right, for whatever that time period is. No matter, even if you have nothing now, you'll still be ineligible until that time period lapses, okay? So this is why it's important to tackle these things in advance. But listen, the good thing, again, to help take the fear out of this, is that a lot of these mistakes, as long as we're willing to start stepping in the right direction, they're avoidable, right? So all the things that there really could be to be afraid about, if we tackle it, we don't really have to be afraid of them, right? Don't get me wrong. There will be other things. Right? Who wants to estate planning? The death and the dying. Yeah, but it's about control, right? There's a positive light to it. We can do a lot of good things now, right? And know that we can take this weight off of our shoulders in moving forward. So talking about that a little bit, the next slide is going to look a little wild, admittedly. So let's jump on to that. We have to just be, I'm sorry. This is not the one that looks wild. Let's talk about this. And I'm glad that I saw this in front of my face before I started talking about something else. This is what I was saying before, right? Planning for everybody, for anyone that's out there listening or that picks this up and listens to it later, it's all going to be fact specific, right? One plan is not going to be the same for another. And what I mean by that, it's not necessarily the components. And when I say the components, it's those big core components that I said before. Those pieces, anyone that's listening now, you're likely going to need those things. But what goes into them is not going to be one size fits all. Okay, that's where the difference comes, right? The distinctions that go in them. I said a memo of intent before to help guide a trustee. That's going to look different for everybody, right? That's a very unique component of planning. But everything matters. How old are your children? Do they have benefits now? No? Might they need them in the future, right? What assets, right? Are there assets now? What kind of assets? Where are they? Whose name? What are your child's abilities now? Right? Sometimes we get a little uncertain because our kids are learning new skills, right? They're developing, and then we get in this sort of limbo. We're not sure. We're not sure what we might need to do. It's okay. It's okay. This is what flexibility is for. This is what planning is for. If we plan, we can add in flexibility, right? The family dynamics, that matters too. That's a big key in your planning, right? Some are different than others, of course. In some cases, I plan for blended families, right? It's a whole other thing, right? It's a whole other arena of, I actually need to think about that. Who goes to what might be a little bit different in those circumstances, right? On each side. And of course, this one big one, right? The availability of trustees, guardians, caregivers, successors. Always a rough one. But the more we think about that and discuss with someone, if we're not sure, who we might be able to use, and if we really don't think we could find anybody, having that might be an entity I'd be comfortable with if I needed it. These are the stuff that takes that burden off, takes that weight off. It's the next slide that's going to look a little wild, I promise this time, okay? A practical next step, all right? I promise you the slide after this, we're going to make it look a little bit lighter. But this is what everybody should do if you haven't done so already. And if you've done it already, do it again if you need to, right? Always be thinking about this. Identify who should serve in the key roles, right? Think about it. You might not have the answer right here as we sit today. You might not have the answer as you think about it on your own, right? But talking it through with someone can absolutely help. But again, some of these key pieces, your executors, your agents, guardians, that could be for minor children or maybe even adult child who might require a guardian, and your trustees, okay? Think about that. A lot of times, just maybe this is a little helpful for helping people conceptualize it. Whoever you choose as your executor, right, the person that would handle your estate, a lot of times that's the same person that you might decide to have as your general power of attorney, right? Because remember I said that's handling your business, right? Those roles can go a little hand in hand. Doesn't have to be the same person, but sometimes it's a good way to think about it. Medical, I would leave kind of out in its own sphere, right? Because sometimes we have loved ones who are sometimes really good in that arena, and some that maybe not so much, or maybe we don't know that they would really share the same thought that we might have in that regard. And then guardian and trustee, right? I think for a lot of the families that I speak with, I like them to kind of think of those together, because a lot of times it makes sense. If there's someone that you would want to take care of your loved one in the event you were not here or you were unable to do so, well, a lot of times it would make sense that that's going to be the person that you want them to do right with the assets that may have been left for your loved one to manage them. Okay? So that's something to keep in mind. Gathering information. This, I think, is the biggest headache, I'm sorry to say. But if we can, this is not the suck it up thing, but if we can grit and bear it and do it, right, this helps. What do we have? What do we have? Right? Let's identify what we have. Real property. Right? What do we have? Do we have one property, more than one property? If we're renting, great. We don't, maybe something we don't have to worry about right now. Will we maybe acquire some in the future? Well, we can worry about that later, right? But accounts. What kind of accounts do you have? How many? Where are they? What type? Whose names are on them? Okay? Whose names are on them? I gave the example before of sometimes putting a child's name on. Same thing with the house. I've had folks that have said, maybe I just put, nope, you could do that. And again, I don't think this is a topic for right this second, but I've had people do that they want to just put a child's name on the house, and there's a lot of reasons to not do that. Don't get me wrong, are there circumstances where it could be appropriate? Sure. Again, not every solution and not every approach is one size fits all, but in many cases that we're working with, especially with special needs, we're not doing that. Okay. Life insurance, right? Do you have policies? Do you have policies that you don't know about? Right? Some people forget, I don't pay for this policy, but I realize my employer has a life insurance policy, right? Well, great, that's wonderful, but let's make sure that if that's the case, let's check the beneficiary designations, right? That's the key, okay? Like I said here, right? Whose name's on that account? Who's on the property? Who's listed as a beneficiary? All key things for us to review. Again, determining whether benefits are involved now or whether they could be, okay? If they are already, which ones? Know the benefits, right? Know the benefits as best you can, and the limits, right? If it's SSI, all right, let's know what kind of income and resource limits there are. Let's learn about in-kind support and things of that nature, right? Let's get that on the table. If it's SSDI, let's know if it's that. If it's Medicaid, okay? And I won't be overwhelming now, but this is why conversations are further sometimes with professionals are helpful is, well, which kind of Medicaid, right? You know, that could play a role in our decision making. But just getting in a grip on what's going on, right? These are the first practical steps before we even start putting pen to paper and fingers to keys to get these things together for you. Obviously, considering special needs trusts and supplementary tools, that's practical. Preparing the memo of intent if you have a plan or getting familiar with it, and that planning for the age 18. Now, I put this on a separate slide. You can go to the next one just to make it look a little less daunting. Okay, there you go. 5 things. 5 things you can do now. All right, it looks a lot better than the slide before, which is really just for my benefit, I think. But this is what we have here. Okay, 1, 2, 3, 4, 5. It's fairly straightforward, and it's a great place to get started. It's up to you guys. I'm happy to take questions now, or I could share some frequently asked questions that I come across in case, you feel that would be good for everybody, but I'll leave it up to, everyone that's running the show and our audience.
I will post a question.
Oh, and this is the tough part, is that I forgot. I can't hear anything. Perfect. So I am, just for my own, making this flow right for me, is that I'm waiting for some questions to be posted, and I will do my best to take a swing at those for you. Okay. First one I see here. When should parents start planning? I think you already started to some extent because you're asking the question and you're posting it. You're here. So parents should start planning if you haven't already today. Okay, you should start planning today. What age is best? Well, I said today. Now, I will say this. I want to keep in mind that what I'm answering right now is very much so geared toward having, a family member or a beneficiary with special needs in mind, right? That, and in most cases, I'm thinking parents with a child, right, with special needs. So when I say that, that planning is absolutely right now, right away. Now there's different levels of planning. Okay. So for some folks, maybe we are now at or nearing retirement age, right? And I'm just using this as an example. Maybe some of the things that we're focused on then might look a little bit different, right? We're always going to have, if we're here and our concern is special needs, we're always going to have those pieces and those components of our planning. But sometimes the lens might, maybe I'll say it expands, right? And we start looking at other pieces because as we start nearing, retirement age, well, I don't want to go outside of my lane, but we now maybe this is when we want to be even talking a little bit more, working more closely with financial advisors that you may have, accountants that you may have. And if you're not, maybe this is the time to loop them in, okay? To bring them into the picture as part of your team if they're not already. Because at the same time, while we're planning for loved ones and their future, and in many cases their special needs, sometimes we forget that we may have special needs, okay, as we age. So we want to also maybe look at that a different light as we get near those ages, okay. Let's see what we have here now. If the child is less than 10 years and parents are in their 40s, is it worth a start? Absolutely, right? And forget about just the I don't want to say estate planning because that's what it's all about. But forget about just the where should my stuff go piece of it, right? All right, right now, all right, child less than 10 years, parents are still in their 40s. What if something happens to the parents within the next year, within the next 5 years? Did we say who we would want to take care of our child that's less than 10 years old? I hope so. We should be, right? We should be doing that. Another thing to think about, remember the part about, well, if you don't have a plan in place, well, then the state gets to say what happens with your assets. Right? So we want to take control over that while we can, right? We don't want to have something arise and we have lost control over that. Another thing that happens too is, let's say we put a will together, okay, and forget about even the revocable trust planning I was talking about before. If we put a will together now and we have parents who are in their 40s and child less than 10, well, we are absolutely going to have a provision in there that says, well, what should happen to funds that are for someone that is under the age of majority, right? And we would want to have our plan say who would have control over those funds that would probably be there for one of our children that could be under 10, under 18, let's just put it that way, maybe even older if we want it to be. Because what could happen is if something happens to you in your 40s and you have this young child and now funds make their way, well, they're not just going to go to that child outright. They're going to go into an account that the state is going to likely have control over. So rather than that, if we plan now, we can put, ourselves on better footing and have more control, right? That key word, and say who we would want to manage those assets as opposed to them sitting in a state controlled account somewhere. But that's a great question. Let's see. Excellent question. Regarding the memo of intent, do you need an attorney to draft it? No, you don't need an attorney to draft it necessarily. I will say this. One of the reasons you don't need an attorney to draft it is because it's a non-binding, right? It's non-binding. What I like to do for my clients particularly is I just like to give them maybe I'll give them I'll call it a handout or something, right? That or a list that can help them conceptualize what types of things they might want to put in it and expand upon. So you don't need an attorney to do. You don't want an attorney to do it, in my opinion. Okay, this is for you, right? You're the one who knows your beneficiary. If it's your child, your loved one, you know them, and that's the whole point. You are the one who wants to give all this information to the trustee, right? And the other beauty about the memo of intent is that you can update it, right? That's the whole point. Is you put your trust, you put the meat and potatoes in place We say what has to happen with assets, what they're supposed to be there. We build in this flexibility, but we do so in a manner to where, again, the details change. Maybe what you intended when you created that trust years ago, which we've revisited, let's say 10 years later, and the trust is still actually sound and everything is good to go. But maybe your intentions, the preferences, right? What your beneficiary, you know, really needed or wanted, or what you wanted for them 10 years ago could be completely different. So no, no attorney for that. That's all for you as the person who establishes the trust. No more questions. Okay, excellent.
All right. So I want to say thank you to,
Now, are we
yeah. So
excellent? I have. Do you want me to do any more questions that I have, or just are we good? Are we full of information for now? Okay. Oh, thank you, thank you. That's me. You're welcome to reach out in the future for any needs you may have.
yeah, so we had some technical difficulties, so we were
Part two
using
sounds good to me.
we're using multiple tools to communicate. But we want to say thank you everyone for watching. This is a lot of information, lot of information, but it was so good. So we will be doing a part two. We'll have Brian come back. Awesome, well articulated, very good. You can definitely get more information from the Freeman Law offices, and you can reach out to him there. But once again, I hope families that are listening know the value and importance of doing this work. And so, once again, thank you for joining us. Because of time, I will just quickly highlight that I'll be doing our annual Bowling for Autism event. It's going to come up very soon. It's actually next week. So next Sunday by this time, we would have been bowling and having a good time. So if you're in the New Jersey area, Sunday, April 26th, at the Circle Bowl and Entertainment in Piscataway, we'd love for you to be a part of it. So join us so much. And for those of you who are inside the Zoom room, we'd love for you to just tell us your feedback. How did you enjoy this program? But what are some of the key takeaways? What else do we want to learn more about? And we'll be able to share that with you for the next time. So I want to say thank you to Brian. Really amazing presentation. I learned a lot. I'm going to definitely process that information that's been shared. And yes, we would do a part two. So on that note, I want to say thank you everyone for being here and have a fantastic night. Thank you. Thank you. All right. So goodbye, everyone. Bye bye now.